Hello and welcome. I will be reading the prosecution's motion for records. I did not read this motion when it was released, but I did provide commentary for the hearing that took place a couple days ago. I believe it was last Wednesday. I provided a commentary video regarding that hearing. So if you watched that video, you know that Judge Beverly Cannoni is supposed to make a decision on this very motion, the motion submitted by the Commonwealth. So I felt it important to read exactly what the prosecution/Commonwealth is asking for in their motion for records. So the document begins. Now comes the Commonwealth and respectfully requests this honorable court, pursuant to Mass R. Crim. Rule 17 and Commonwealth versus LePron, and provides the case law. And they are also asking the court to issue a court order to Verizon Security Assistant Team. It continues, ordering the keeper of the records of Verizon Wireless to produce to the criminal clerk's office of the Norfolk Superior Court 1. Subscriber information associated with the Verizon phone number from December 30th, 2021 through January 30th, 2022, belonging to Janet Reed of Dighton, Massachusetts. And number 2, records for all call records and call detail records for the period of December 30th, 2021 through January 30th, 2022. In support of its motion, the Commonwealth states the following. 1. On January 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree murder in violation of GLC 265 subsection 1, manslaughter while operating under the influence, in violation of GLC 265 subsection 13.5, and leaving the scene of personal injury/death in violation of GLC 90 subsection 24 2A.5 2. And then number 2, on January 29, 2022, the Commonwealth alleges that the defendant struck the defendant with her car. Okay, interesting wording. The Commonwealth alleges that the defendant struck the defendant with her car and caused his death. The defendant returned to the victim's home after striking the victim with her vehicle and leaving him incapacitated in blizzard conditions. Through the evening and morning of the victim's death, the defendant made numerous calls to various people providing varying and conflicting statements about the whereabouts of the victim. The defendant's phone call records identify calls to both William Reed and Janet Reed, and texting between William Reed and Karen Reed. The Commonwealth intends on calling William Reed as a witness to testify to some of the various admissions made by the defendant. Specifically, in the Boston 25 News aired segment, reporter Ted Daniel asks William Reed, quote, "During your first discussion with Karen, did she believe she may have hit John?" End quote. William Reed responded, quote, No. She felt she struck something. She said, "Dad, I think I struck something." I said, "What do you mean?" "Right. This was in the hospital." "Right." She says, "I remember, all right, backing up and hitting something." End quote. Okay, I'm going to keep reading, guys. Number 4, contrary to that account, the defendant's first discussion with William Reed was not when she was in the hospital. Rather, the first conversation occurred before the defendant was transported from the crime scene. William Reed and the defendant conducted their first call at 2:32 a.m., which lasted 3 minutes and 6:32 a.m. I'm going to read that again. Sorry. Contrary to that account, the defendant's first discussion with William Reed was not when she was in the hospital. Rather, the first conversation occurred before the defendant was transported from the crime scene. William Reed and the defendant conducted their first call at 6:32 a.m., which lasted 3 minutes and 51 seconds. Medical records note that Karen Reed was admitted to the hospital at 7:26 a.m. Number 5, the Commonwealth seeks the phone records of Janet Reed in 2 separate areas: subscriber information associated with the Verizon phone number belonging to Janet Reed of Dighton, Massachusetts, and 2, records for all call records and call detail records for the period of December 30th, 2021 through January 30th, 2022. Janet Reed's phone records must be made available to use as potential impeachment evidence depending on the testimony of William Reed. The time scope of this request extends 30 days prior to the evening of alleged criminal activity. However, the content of the request is appropriately narrow and strictly limited to what is relevant. This limited request is made to best protect Janet Reed's privacy rights while allowing evidence to compare the timing and frequency of Karen Reed's calls to her mother on the night of the victim's death as compared to the frequency or lack thereof on dates not involving this alleged crime. Number 7, the defendant's knowledge that she struck Mr. O'Keefe is irrelevant to the charges. I think they're missing a word. The defendant's knowledge that she struck Mr. O'Keefe is irrelevant to the charges. The defendant's apparent conduct soon after the Commonwealth alleges she struck Mr. O'Keefe with her vehicle is an inference of her knowledge that she struck Mr. O'Keefe. The timing of the defendant's knowledge is also relevant and material in the determination of whether life-saving measures could have saved Mr. O'Keefe's life. Janet Reed's phone records are material and relevant to demonstrate the regularity or irregularity of the defendant's regular communication with her mother in the late hours. The records would be unattainable during trial or would cause a significant delay in trial, and prudent preparation requires acquisition of the records prior to trial. The records are not otherwise procurable reasonably in advance of trial, as they are not held in the care, custody, or control of the Commonwealth or defendant, and the entity will not produce the records without a court order. The Commonwealth cannot properly prepare for trial without such production and inspection in advance of trial, and the failure to obtain such inspection may tend unreasonably to delay the trial. And number 10, an affidavit in support of this motion is attached. For the above stated reasons, this motion should be allowed. Respectfully submitted. For the Commonwealth, Hank Brennan, specially appointed Assistant District Attorney. Specially appointed. And it's dated November 15, 2024. But I'm just going to provide a little bit of commentary. Right here, the Commonwealth cannot properly prepare for trial without such production and inspection in advance of trial, and the failure to obtain such inspection may tend unreasonably to delay the trial. Like, that's Hank Brennan, that's the prosecution, saying, like, make this order or we won't be prepared for trial. And it's like they're saying, our case will be harmed, Judge, if you don't order Verizon to give us those records. Which this argument in and of itself is weak. It's, as I said in the commentary video pertaining to the hearing, it's a weak argument. It's like grasping at straws, and just right here with the quote that Hank refers to: during your first discussion with Karen, did she believe she may have hit John? And then allegedly William Reed says in response to the interviewer, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right, this was in the hospital. Right, she says, I remember. All right, backing up and hitting something. when Judge Bev and Adam Lally sat through the trial, and there was video footage everyone watched in which Karen Read was backing into another vehicle and tapped it. It made contact. And I also think this is, as I said in the commentary video, I think this is an attempt by the prosecution to put pressure on Karen Read's family as a whole, that they really want Karen Read to go down for this. They don't care that no real investigation was conducted by the state of Massachusetts, by the prosecution, by the MSP. Like, no real investigation was conducted. And the prosecution themselves didn't even do any real research. They completely overlooked the conclusions that the federal government came to. The prosecution completely overlooked the conclusions made by actual accident reconstructionists. And for the prosecution to think that a phone record from Karen Read's parents, phone records from both of Karen Read's parents, providing call logs, is going to, to me, it's only going to be speculation. Like, let's say if Karen Read really didn't communicate much with her mother or with her father a year leading up to January 30th, 2022. Like it's whatever reasons the prosecution comes up, it would be speculation, because the prosecution wasn't there for those interactions. The prosecution wasn't there for those phone conversations, and they are only relying on the call logs. They would essentially be relying on Karen Read's patterns, her phone call behavior between herself and her parents. To what? To speculate that because, like, for instance, because maybe Karen Read's phone calls with her parents were different a year leading up to January 2022. It's like, it's just weak. It's a weak argument, guys. It's not going to give the prosecution anything that's concrete. And any conclusions they draw from phone records a year leading up to January 2022 would be speculation without them knowing the context of the phone calls, which they cannot get from phone records. They also cannot get context from phone calls that Karen Read made the morning of January 29, 2022. Like, they fluff this up with, oh, let's protect the privacy of Janet Read's phone records, phone records or phone data. We don't want any, like during the hearing, they said that we don't even want data extractions. We just want to look at the call logs. It's like Hank Brennan is an attorney from the 90s, from the 80s. It's like you're going to really refer to call logs like this is the 1980s and call logs are all you have, right? Like, this is 2024. Like, we have far more than call logs, right? Like, but all he wants is the call logs. Again, to what? To speculate on what it means without context, to provide a narrative that will not actually be fact-based, much like the original narrative the prosecution had, right, against Karen Read. That narrative was not fact-based. It was a cover-up, first of all, and it was also speculation. They didn't have a single piece of evidence to back up their claims against Karen Read. And And if they're going to go at it like this, through this approach, just relying on call logs for phone calls, which they will have no context for, they will not know what Karen Read said or what her parents said during those phone calls. It will again just be another narrative that is not fact-based. It's not backed by any facts. The prosecution's argument against Karen Read the first time around was speculative. And this time around, it will again be speculative. So before I briefly read Judge Beverly Cannoni's conclusion as to the Commonwealth's request for records, I wanted to show you some screenshots I took from the Court TV YouTube channel, as well as the Law and Crime YouTube channel. How the sensationalism continues. So this video was titled by Court TV as Karen Read, Victim or Villain, Pre-Trial Hearing Recap. And look at how they spliced two photos of Karen Read. One where she seems sad, discontent, and the other where she appears to be smiling rather happily, in my opinion. She doesn't. What I'm saying is, in neither photo does she appear to be a villain to me. But do you see how Court TV continues with the narrative, victim or villain? This is what I'm talking about when I refer to Court TV and other mainstream media channels, not just on YouTube, but on other platforms too. This is how they make their money, people. They don't really care from one case to the next. They don't care about the lives they talk about. They don't care about the human beings they talk about. Karen Read is just another case to them, and they don't really care that she's innocent. They don't really care that she was, for all intents and purposes, acquitted in the eyes of science and the court of public opinion. Court TV does not care. They just want your clicks. They want your views, and they want to continue presenting stupid videos like this so that you will click on them. But I'm actually glad to see that this video, according to the screenshot, only received 24,000 views. I know of free Karen Read YouTube channels that are getting a lot more views than that. So that's also telling. Court TV is getting fewer views than some of the free Karen Read YouTube channels. Here's another one. This one gets under my skin so bad. So bad, guys. It's like, Karen Read back in court, quote, "She did something terrible." See? She did something terrible. And look, 37,000 views. It's up from the previous video they submitted. She did something terrible. That's such bullshit. And what was that video, guys? It was the motions hearing. And nowhere during that hearing was it disclosed that Karen Read did something terrible. In fact, the defense completely shot the prosecution's argument out the window when the defense said there was no phone call made at 1:30 a.m. It was made after 6 a.m. What is the prosecution even talking about? She did something terrible. It's clickbait. Court TV is all about clickbait. And they don't care how the public views Karen Read. They don't care how their videos and how the titles to their videos influences public opinion about this innocent woman. Court TV sucks. And this is one from Law and Crime Network. Boyfriend or cop murder trial. And in very small print, Mass v. Karen Reed. Just another channel sensationalizing the situation, despite Karen Reed's proven innocence, and despite the Commonwealth's and the Massachusetts State Troopers and the Norfolk County DA's office proven corruption. These YouTube channels, these big YouTube channels, don't give a damn who Karen Reed is or what the actual facts of the case are. Boyfriend cop murder trial. They don't even care about John O'Keefe. He's just a boyfriend cop. They won't even give him a name. So another thing I've noticed is that there is very little coverage of the fact that Judge Beverly Cannone denied the prosecution's motion to release the records, the phone records. And you can search right now on YouTube if you want to, guys. Today is Monday, December 2nd, 2024. Look on YouTube right now. How many YouTube channels are talking about the fact that Judge Beverly Cannone denied the prosecution's motion to release phone records? I've seen 2 very small YouTube channels, local news YouTube channels. That's it. Not Court TV, not Law and Crime, not the big YouTube channels, not even the bigger YouTube channels that are free Karen Reed. Not even they are discussing the fact that Judge Beverly Cannone denied the prosecution's motion to release phone records. And to me, this is a big deal. It's a big deal. It's almost like Judge Beverly Cannone turned over a new leaf. I don't know. It's like, I'm not going to trust her. Till the end of this lifetime, I will not trust Judge Beverly Cannone. However, she denied the prosecution's motion, and that's a big win for Karen Reed and her parents. So what is that? What does that mean, guys? Like, when things are going in Karen Reed's favor, the YouTube sensationalism quiets down, right? Because is it that Court TV and Law and Crime Network, they only generate the most views from controversy, from drama, but because it's actually a happy thing, it's a good thing that Judge Bev denied the motion, Court TV isn't going to talk about it. They want to only talk about the things that go against Karen Reed. So this is a brief excerpt from the article. I'll leave the link in the description below. I only took 2 screenshots, guys, because the article just goes into the backstory. And I tried finding the court filing submitted by Judge Bev herself, but I could not find it. If I find it in the next few days, I will read her entire decision. But for now, this mainstream media news article will have to suffice. So it reads, motion for release of phone records denied in Karen Reed case. And it shows Karen Reed and her parents. It reads, a request by prosecutors in the Karen Reed murder case for the release of phone records between Reed and her parents on the night of John O'Keefe's death has been denied. And this is the last screenshot. Judge Beverly Cannone denied the motion Friday afternoon, writing, quote, despite the detailed arguments articulated in the supporting memorandum and at oral argument, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of Lamprom and Massachusetts Rules Criminal Procedure 13A2. End quote. The prosecution can submit a motion for reconsideration so that Judge Bev can look at their motion if maybe they revise the affidavit so that the affidavit is more succinct. Or maybe they revise their arguments so that the arguments do meet the 4 prerequisites under Lampron. So I'm just saying there's still a chance that the prosecution can file the motion again after they revise it and make it stronger. But for now, it's a good thing that Karen Read's parents will not be harassed and unnecessarily brought into the case like the prosecution wants to do. And again, to me, the prosecution wants to bring in Karen Read's parents to apply pressure to the family, to put the entire family under more stress than they've already experienced under such corruption, such blatant corruption. In my opinion, Hank Brennan is playing dirty. And it's not over yet. But it's a good battle won, at least in this case, at least with this motion. Karen Read won this battle. But the war continues. Thank you for watching.